At a Senate Judiciary Committee hearing on July 30th, Senator Chris Coons questioned Ninth Circuit nominee Joshua Dunlap about his views on precedent-setting court decisions, pressing him on how he'd approach longstanding legal rulings if confirmed.
Mr. Dunlap, I want to talk about one of the pillars of our judicial system, stare decisis. You've written a blog post for your firm about when it might be appropriate for a court to overturn established precedent if confirmed. When would it be appropriate for you to draft an opinion overturning First Circuit precedent?
So First Circuit precedent could only be overturned en banc, and the court would consider the importance of the issue raised, would consider potential conflicts with other cases in determining whether or not to take it en banc. And if the court did take a case en banc, you would consider a variety of factors. You would consider reliance interest. You would consider the quality of the legal reasoning. You would consider subsequent...
Help me understand, Mr. Dunlap, if you might forgive me, the contours of reliance interest.
So the reliance interest is the extent to which parties may have shaped their conduct in a way that is relying upon the existence of a particular precedent.
And would a precedent that had been well settled for, let's say, 50 years be one that would likely have produced reliance interest?
That would be a possibility. It would certainly be a consideration that the court would need to take into account.
What would you do if asked to apply Supreme Court precedent with which you disagree?
I would be bound by the rulings of the Supreme Court.
And what are the contours of being bound?
I mean, you need to look as a judge at the facts and the legal reasoning of the case, determine how it applies to the case before you. But the court's holding is binding on lower courts.
For more congressional news, stay tuned to Congress Clips, and thanks for watching.